How would you want me to do this? Because this thing is very thick. Not the thing, excuse me, I'm not meaning, I don't mean it bad. The book is very thick, very informative. So how do you want me to do justice in 30 minutes? And I told him what I want to do, and he said, you are spot on, John. So mine is a commentary and a contribution on the Namibian Constitution, the book, with the subtitle, A Comprehensive Guide. I've decided to do it in two ways. As I'm asked to do a commentary, I start with general comments. And then I'm asked also to do a contribution, and then I'm going to make contributions. But in 4 specific areas in which I think, as a part of us reflecting on our constitution, what that should be. Firstly, in terms of general comments, as the subtitle indicates, a comprehensive guide, one can say without fear, favor, or prejudice, that the book that has just been launched is indeed a comprehensive guide. For any legal scholar, researcher, it is comprehensive in terms of the most up-to-date, at least up to 2021, 2022, excuse me, even then, up to 2022, very uniquely Namibian jurisprudence. My students in my classes do not understand why John insists on them bringing to the class Namibian case law. Because you are not prepared primarily for going and practicing in any other foreign jurisdiction, but you are primarily going to practice, most of you, as legal would-be lawyers in Namibia. And it's in that context, Prof, that I really appreciate the fact that there is so much up-to-date Namibian case law reflected in this textbook, in the guide. The guide, as was mentioned, comprises of 5 parts, and I've counted the chapters, if I'm not mistaken, 31 chapters, touching on a wide range of issues, giving insights into both historical, political, legal, and contemporary issues facing the country. When I read the book, or when I start reading the book, I think very early in the book, the first pages makes a very political statement, yet legal also, of course. And it says that Namibia was not terra nullius. In other words, no man's land. At the time when the colonial settlers and missionaries arrived, our people were here. The land belonged to the people. And with this statement, and of course, so that is how the book starts. And then even though Professor Hinz mentions that they are not really delving into the issue of same-sex marriages, but up until 2022, at the time of the writing of the book, the Dikgato case was already in there that deals with the question of same-sex marriages. And of course, the latest decision of the Supreme Court, for obvious reasons, is not reflected. But it just shows you, starts from the pre-colonial times, and it ends as late as issues dealing with same-sex marriages. That just shows you how current and topical the book in question is. Going further with regard to my general comments, I said when reading this book, and I think I've already mentioned, the interested reader is spoiled by choice. You can literally choose I want to read about the pre-colonial history. I want to read about the provisions that deals with property rights in the Constitution. I want to read, like me, the provision in the guide that deals very specifically with administrative justice. And by the way, Prof, I found it very interesting that the chapter on administrative justice is the longest chapter in the book. And I said, John couldn't have been more spoiled with choices. So, for example, as I said, the guide is dealing with a lot of issues. For example, those interested in the issue of decoloniality, you go to chapter 1, part 1, chapter 1 of the Constitution, and you go and read where we're coming from, what the German colonial government did, what they have done to the Ovaherero people, the Nama people, and to all others, the Damaras, the San, you name it, how that history of dispossessioning people, discriminating against people, treating people unfairly, disempowering one group, and at the same time privileging others. If you are interested in that kind of legal social history, then you go to chapter 1 of part 1. It's very rich in terms of making you understand where we're coming from. But that chapter, also, Dennis, gave me a lot to think about. It, of course, as I said, shows that the law during both colonial and South African colonial periods was used as an instrument to impoverish the black majority while privileging the white minority. It is not so much as I now putting it, but that is the gist of chapter 1, part 1 of the book. But then it shows that in this regard, the Namibia which we are celebrating today, there are some mixed outcomes. The question is whether we lived up to the ideals and values of the Constitution. More about this as we proceed. And that brings me, with that said, that brings me to the point of making very specific commentaries. The first one is on, as the guide mentions, also touches on, and that is the issue of locus standi. The question of who may approach a court when you are aggrieved, as Article 18 of the Namibian Constitution provides for, and Article 25(2) of the Namibian Constitution provides for. As the guide mentions, it is very unfortunate that the common law rules of standing is unfortunately, we haven't achieved much in decolonizing the common law rules the common law rules on standing, which is very narrow, restrictive, and exclusionary. It says that when you go to court, you need to have a direct and substantive interest in the outcome of the matter. In the words of Judge Parker, you are not supposed to be a busybody because the court doesn't have time for that. And meanwhile, and of course, the sad reality is that, as was also mentioned, as mentioned in the guide, this narrow, restrictive, exclusionary rules of locus standi has been confirmed as late as 2016, 2018 by our superior courts. In the Nemrights case, as mentioned in the guide, and Prof, I'm not so sure whether you mentioned the Tumult case, about 8 people claiming a tosha, which has been from the Highton community, that has been taken from them in the midst of winter in 1955 by the South African Constitution, by the South African colonial government. These 8 people are saying, as a class of people that has been dispossessed without being given fair compensation, we are coming to our courts, the High Court and then the Supreme Court, asking for permission to bring a class action for social justice, reparatory justice, to our courts to claim back a tosha. Both the High Court and the Supreme Court say, you don't have standing. Is justice served? Very interestingly, reflecting those that has written their constitution after us. South Africans, 1996, the Kenyans, 2010, the Zimbabweans, 2013. They have said, if we really means justice, then we can't cling to the colonial notion of locus standi. We need to decolonize locus standi. That is why in South Africa, in Zambia, in Zimbabwe and Kenya, they have introduced class action. They have introduced public interest standing. And Namibia, we say, no, we're so much in love with the colonial notion of locus standi that we are not prepared to rock the boat. And I'm saying maybe it's time that the Law Reform Commission must take the bull by its horns. I know there was a project whereby they wanted to enact a law to broaden locus standi. The question is, how far is that process, Madam Minister? Another contribution relates to the issue of equality and non-discrimination. Article 10, the guide is reflecting on that. The guide, in fact, provides valuable jurisprudence on equality and non-discrimination. It shows that the Constitution embraces both formal and substantive equality. It shows, however, the fault lines of the non-discrimination clause, that is Article 10 of the Namibian Constitution. It has been confirmed by both the High Court and the Supreme Court. First one was where it was mentioned in the case that is dealing with the man that is changing the wife's surname, is the Muller case. It has been confirmed in the Muller that Article 10.2, is a clause list. It only provides those prohibited grounds of discrimination listed there and nothing more. That is a serious shortcoming. It's a pity that the speaker left. That is a serious shortcoming because the UN treaty bodies have actually said Namibia should do something about that narrow grounds of prohibited ground, the narrow prohibited grounds listed in the Article 10.2 of the Namibian Constitution. And we are saying you don't need to have sexual orientation there. You don't need to have disability there. You don't need to have all these other controversial things there. Do us a favor, members of parliament, amend it by just saying amongst others. In other words, no one may be discriminated against. Leave those things there. But just bring in something that says amongst others, including race, color, sex, and whatever you are having it there. You would do us a great favor. Those that believe in non-discrimination, that is enough. Because that would give those ones that claim that they are being discriminated against based on their sexual orientation enough ground to say amongst others. And not the way it is now closeless. They can't do anything because in Visser, the Visser young boy, a 19-year-old boy, he got paraplegic. And of course, he was a bit rough, and he claimed that the MVA fund is discriminating against him by treating him as if his situation is just like anyone else. He wanted to claim that he's being discriminated based on his disability drawn from social status. The High Court and the Supreme Court says disability is not a ground for non-discrimination. That is the sad part of Article 10.2. And this is what the guide is mentioning. It is close, it is narrow. The guide is also pointing out a very serious trend that some of us are observing in the Namibian landscape. And that is the use of so-called neutral terms for previously disadvantaged persons. It may seem neutral, but it is actually not that neutral. Because we have seen that by the use of the term previously disadvantaged, ministers, governors' wives, and you mentioned it, people that can afford to go to Agribank to get a loan, affirmative action loan scheme, they are the first to stand in the line of the government's resettlement farm program. Can they do that? Yes, they can, because the policy says previously disadvantaged. By using this term, the guide is pointing to this fact. By using this so-called neutral terms, we are actually indirectly discriminating and perpetuating the discrimination where we're coming from. So the guide is alerting us to the dangers of that. My second last commentary is on administrative justice. Prof, I've mentioned it. This is my favorite chapter. And it goes with, I don't know why is this also incidentally the longest chapter in the, it says something about you. Be that as it may. Just for, by way of background, the guide made it very clear that Namibia set the trend when it comes to the entrenchment of administrative justice. I've read a book by Prof. Corder from the University of Cape Town, And he says, in common law Africa, Namibia was the first country that entrenched the right to administrative justice. South Africans copied from us, Kenyans copied from us, the Zimbabweans copied from us. So we set the trend to entrench the right to administrative justice in Article 18. And the guide makes it clear that Article 18, the right to administrative justice, extends to citizens and non-citizens. And the Kessel case is a proof, case in point, because it says anyone that is aggrieved with a decision taken by an administrative official or an administrative body may approach a tribunal or a court of law. The guide affirms what has been said by the High Court. Article 18 has propelled us to move from a culture of authority to a culture of justification. Culture of authority where those in charge could just do whatever they think and wanted to do. That is the culture where we're coming from. To a culture of justification where a decision must be justified. One way of justifying it is say, you provide reasons. Why did you take reasons? And this is confirmed in the guide with rich Namibian jurisprudence. The guide is also affirming that the courts have actually done almost the unthinkable, has broadened the conventional way of, has extended actually the conventional understanding of administrative justice. The courts, as the guide is showing, has reviewed and is currently also still reviewing decisions which does not ordinarily amount to administrative decisions. Decisions of cabinet, decisions of the Speaker of the National Assembly, they are not reviewed as the guide is indicating under Article 18, but they are reviewed in terms of the principle of legality and the rule of law. The guide also shows so strong is in terms of our Constitution, the commitment to administrative justice, that the principles of administrative justice has also been extended to political parties. Political parties can't just deal with their members the way they want to. The court would look into your own constitution to see whether you have complied, whether your view or your decision is consistent with your own rules and stuff. Churches, political parties, and even trade unions, and the list goes on. And this is what the guide is affirming. The last one, my last commentary, is on directive principles of state policy. Chapter 11, if I'm not mistaken. But chapter 11. Chapter 11. Chapter 11, Article 95. I must choose my words here. No. In fact, it's my least favorite chapter in the Constitution. My least favorite chapter in the Constitution, to be very honest, and I stand to be corrected, we will not be worse off if we were to take out this chapter, especially the part where the constitutional drafters fell in what I'm saying, fell victim to the Cold War that was still at play at the time when our Constitution was drafted. At the time when our Constitution was drafted, there was a group of companies that felt civil and political rights are the first generation rights. And these are the rights that the state should be, that should most be enjoyed in whatever. And there was this other, and those were obviously countries from the West, like the US, Germany, and so forth. And then there was the other countries, the socialist, the communist countries on the other parts of the world that did not so much emphasize civil and political rights, but for them it was economic, social, and cultural rights. So there was this divide. And the Namibian Constitution unfortunately fell foul, if my English is proper, to that divide. The Namibian Constitution, as the guide indicates, separate in chapter 3, our Bill of Rights, you will predominantly find civil and political rights. And then in chapter 11, under Article 95, you will find issues that reads like civil and political rights. But they are not couched as civil and political rights. They are framed as directive principles of state policy. And to make it worse, Article 101 of the Constitution says these nice things that the state must do, they're actually not justiciable unto themselves. Don't come to the court and say that they were supposed to. No, the state say they will help, these principles will only help the government to make laws and policies and so forth, and as far as the courts is concerned, is to serve as an interpretive guide. I want to conclude with 2 points. Article 95 of the Namibian Constitution is inconsistent with the African Charter on Human and People's Rights. The preamble of the African Charter states civil and political rights. Now, economic, social, and cultural rights cannot be disassociated from civil and political rights. Or is it the other way around? Economic, social, and cultural rights cannot be disassociated with civil and political rights. And then it makes the strong point, the preamble of the African chapter. It says, the enjoyment of civil and political rights is a conditio sine qua non for the enjoyment of civil and political rights. Social and political rights. Civil and political rights is a precondition for the enjoyment of economic, social, and cultural rights. What would it help someone not to be tortured, to freely express him or herself, as our Constitution provides, but that person doesn't have food to eat, doesn't have water to drink, doesn't have proper sanitation, and so forth? What would it help? People would say, take your peace. Take your stability. We don't care anymore. What we care about is the fact that we do not have anything to eat. For the politicians and members of parliament, I say, do us a favor. My clarion call is, we hear that you're going to amend Article 4 of the Namibian Constitution, which is very good. That's the idea of cabinet has taken, that Article 4 of the Namibian Constitution will be amended so as to give citizenship by descent to those people who fled to Botswana and elsewhere during the German colonial period. Well, do us a favor. Don't just amend the Constitution on a piecemeal basis. Maybe roll it out to amend the Constitution. Because there's a lot of other things where our Constitution needs serious amendment. But for now, based on my commentary on the principles of state policies, I would say amend the Constitution also in this regard. And my clarion call is take ESCR rights, economic, social, and cultural rights. Take it to where it belongs. It belongs in chapter 3 as enforceable rights, fundamental rights and freedom as guaranteed under international law. It does not belong in chapter 11, specifically not under Article 95. With that, Dennis, I think